All right, welcome back, everybody. Today we have another episode of Divorce Well in Florida, What to Know Before Your Spouse Does. I'm Matthew Waring,
And I'm Brian Dunmire.
and we're both partners at Fairway Law Group. We're a Florida divorce law firm. And today we're going to talk about mandatory disclosure. And mandatory disclosure is the bane of everybody's existence that's going through any sort of family law case, but it is mandatory in most cases, and we'll talk about the exceptions. You may have, if you've listened to any other podcast episodes, you might have heard us throw around the term mandatory disclosure. You might be going through a situation where you're dealing with it. You just want to know more about what it is, why we do it. We're going to talk about that today. So, Brian, why do we do what we do? Why do we do mandatory disclosure in divorce cases?
Because it's mandatory, not optional.
Right. Well, there are a few exceptions to that, which we will talk about later. But from a practical perspective, a divorce is a lawsuit, right? And it's a formal lawsuit in circuit court here in Florida. And like any other lawsuit, there's discovery. Before you can go to trial, you got to get your discovery done. And that's what mandatory disclosure is in family law. It is how we conduct discovery so that we're actually prepared to go to trial and show the judge what our clients are entitled to. So with that said, I'm going to let Brian kind of air some grievances about mandatory disclosure here.
Yeah, absolutely. I'll try and give a little bit more serious answer than because it's mandatory, but it definitely is the bane of our existence as attorneys. It's the bane of clients' existence because it's extremely invasive and it invades your privacy. Whether or not that's a legal thing, that's a different discussion, but nonetheless, there's a lot of information that's given that ultimately is going to result in credit card charges being seen and things of that nature. Clients also don't like it because it's expensive from an attorney standpoint. We've got to build time to review it and make sure that the documents match up, to draft financial affidavits. So there's a lot of reasons why it creates friction, or it's kind of oh my gosh, I hate mandatory disclosure. Oh, this is such a pain in the butt. And one thing that I know I tell my clients is every case, it seems as though it's climbing an uphill mountain. And we've got a pretty good process here at Fairway Law Group with the way that we handle mandatory disclosure between intake calls and speaking with paralegals and having attorneys review the documents and getting it sent out timely and everything. But as good of our process is, it's still just it's like going to the dentist for a root canal. No matter how great a dentist you go to, it's never going to be a pleasant experience. It's only how less unpleasant the dentist can make it. And actually, I don't know that I've ever heard an attorney compare mandatory disclosure to a root canal before, but I feel like that's actually fitting. Something that's necessary to be done to stop the bleeding, to end whatever you're going through. And, it's not a pleasant process. But with that being said, it's also, with all the bad things, with all these kind of negative things I'm saying about it, if you're able to just get documents and just follow instructions and do a little bit of basic organization, it really isn't that difficult. If you are a high net worth earner and you've got an accountant who handles everything for you from a financial standpoint, filing taxes and bookkeeping and things like that, you're going to be way ahead of the game because they can just package everything up and send it over to us. Although that's not everything we need. Your accountant probably isn't going to have things like your credit card transactions. They might, depending on how they access them, but you're still going to need to do some work. But it's kind of one of those things. It's not a fun process. It's very cumbersome. It's time sensitive and time consuming. But really, if you just kind of sit down and you just go through it, a lot of people don't really have that much stuff that they have to send over. A lot of it you're going to be able to pull online: W-2s, credit card statements, checking account statements, retirement statements, things like that. So it's a very arduous or difficult process, but it's not impossible by any stretch of the imagination.
Yeah, so I just wanted to, so everybody can know that we're not just blowing smoke. I just wanted to read from the rule. So, Florida Family Law Rules of Procedure 12.285 governs mandatory disclosure, and it applies. The language of the rule actually says this rule, the mandatory disclosure rule, shall apply to all proceedings within the scope of the rules, except those involving adoption, simplified dissolution, enforcement, contempt, and injunctions. So if you're seeking a divorce or a modification of a divorce, you are going to be governed by mandatory disclosure. Mandatory disclosure is not required in simplified dissolution of marriage cases, which we'll talk about later on in this episode. Why simplified divorce is good, why it's bad, who it's for, who it's not for. But far and away, a majority of divorces, a lot of divorces, it's not going to be simplified. And you're going to need to both parties are going to need to comply with this rule, 12.285. And what 12.285 says is that for any initial divorce proceeding or supplemental proceeding, like a modification of a divorce, mandatory disclosure is required. And it says that you've got to produce a financial affidavit, and you've got to produce federal and state income tax returns. Now, we live in Florida, so there's not going to be a state return unless, you filed state income taxes in a different state. If you have like a business outside of Florida and you've made income from outside the state, you might have to file a state tax return in that state, but we won't get into that. IRS forms, W-2s, 1099s, K-1s. I mean, we're talking everything. We're talking pay stubs for the last 3 months, loan applications. You applied for a car last year, we're going to need to get that loan application. Why? Well, if you think that your spouse might be, artificially decreasing their income in order to avoid paying alimony or to reduce alimony or reduce child support, they might kind of, on their financial affidavit, take some liberties in reporting their income, or if they're in any sort of position where they can kind of control how much money they make, people that work in sales, people that own their own businesses, whatnot, when they're going through a divorce, they might stop working as hard. They might stop earning as much income. But if they applied for a car last year, well, obviously they want to get the best financing available, right? So they're going to accurately report their income on the loan application so we can compare those things. That's why it's important to get these things. Deeds of property, promissory notes, bank statements, checking accounts, savings accounts, money market funds, CDs, brokerage account statements, 12 months, most recent statement of any retirement, 401k, 403b, pension plans, declarations pages for life insurance policies, business tax returns for the last 3 years. If you have any ownership or any business interest whatsoever, which is greater or equal to 30% of the business, you have to submit your business tax returns for the last 3 years for any business that you have an interest in over 30%. You also got any other documents supporting any claim that any property is non-marital. You have to back that up. And all of that has to be produced within 45 days of service of the initial petition. And let me tell you, people take this rule very seriously. And that's a joke.
Yes, the rule requires that these documents and what's called the certificate of compliance, which is the client's attestation that they have produced all of the documents that they're in possession of or possession, custody, and control of, is filed within 45 days of the date of service. This sometimes gives respondents, which would be if your spouse filed for dissolution and handed you the paperwork. On paper, it does. You have 45 days from the day that they handed you the paperwork, but you're at a little bit of a disadvantage. We get a lot of phone calls from people on the 19th, 20th day saying, hey, I think my deadline's coming up. I need to get something filed. And, if you subtract 20 days from 45 days, that's 25 days. So then we're left trying to scramble and get everything together in 45 days. I'm sorry, 25 days. So if you're the respondent to a petition for dissolution of marriage, if your spouse filed a dissolution action against you, sometimes you kind of start from a little bit behind, just because by the time you get an attorney on board, there might only be 30 days or something along those lines. With all that being said, this is a nice thing about family law is we certainly want to comply with court rules, and we as attorneys certainly try to comply with every court rule that we can. A lot of that does depend on the client, though, getting us information that we need, signing documents, cooperating with us, getting everything over to us, things of that nature. But it's probably not going to be the end of the world if you're I want to choose my words carefully here, a day or two late on this, or if you think you're going to need another 20 days to get the documents or something. Usually we as attorneys can work that out with the opposing side, and it's really not that big of a deal. My client's just waiting on getting her W-2s. Can you give us another week? No problem. That's fine. However, where it starts to get a little bit dicey is if your spouse has all of their in order, and they respond to the mandatory disclosure, on time or early. We'd like to do it early if we can. And then you're left sitting there and you haven't responded to it. And again, a day or two, a week, not going to be that big of a deal. But if you're in the scenario where you're the one who hasn't responded and it's 30, 40, 45 days after the deadline, but your spouse has responded, sometimes the court will actually see that when they do their own docket review and issue what we attorneys refer to as sua sponte, which just means on the court's own initiative. They do it without any action from attorneys saying that, hey, Dunmire, you and your client have 5 days to get all your mandatory disclosure over to opposing counsel. And it's just not a great scenario to be in. So the 45-day deadline, it's a deadline, it's a court rule, we want to comply with it as attorneys. We don't give legal advice on this podcast, but you definitely should be complying with court rules and court orders and deadlines. But practically speaking, if you're a little bit late, it's usually something that the other side will say, yeah, that's fine. Don't worry about it. Just get it to me on Friday. A lot of times the other side will be late on it too. So you'll just both agree, hey, let's just in 2 weeks, we'll get it over to you. But what is really important about getting mandatory disclosure completed is you're not going to be able to do anything really of any merit in the case until that mandatory disclosure is done. There's certainly exceptions to that, but generally speaking, a motion for temporary relief, a motion for temporary attorney's fees, a motion for temporary child support. The rule states right in the rule, I can pull it up and tell you the time frames, that if you want to have one of those types of motions, you have to have your mandatory disclosure filed X amount of days. It's typically about 10 days before the motion, and some judges might even modify that and make it a little bit longer. So if you want a motion, if you want your attorney to do a motion for temporary child support or something along those lines, you have to do your mandatory disclosure. So it all kind of runs in a chain. So as family law attorneys, every case certainly is unique and presents its own unique facts, scenarios, issues that arise. But in addition to that, there's also the widget side of it. And every case also has a widget side of it where it's do this, do this, do this, do this, do this, do this, do this. And the first thing is going to be file a petition or a response, depending on if you file the petition or not. And then really the next thing is going to be mandatory disclosure. There's a few other called sub-tasks in there, but really the next big thing is just going to be mandatory disclosure. And so you've got the petition and the mandatory disclosure. And if you can't finish mandatory disclosure, case is just going to kind of sit there. There might be a few ways to push it along or something, but there's not going to be anything meaningful that happens. And ultimately, there's just going to be nasty Graham court orders coming against you saying you've got to complete it. So it's definitely, you've got to go through the process of getting the documents over to your attorney, working with your attorney. And the more you're able to do, and this is something at our law firm, we we'll hold your hand, we'll walk you through it, we'll do as much as you need us to. But on the same token, if you're capable of logging into your Capital One account, into your American Express account, into your Truist checking account, your USAA checking account, whatever it is, and just simply downloading the bank statements and sending them over to your attorney in nice clean PDF format, maybe even you can rename the files so they actually make sense. So it's not 1234 ASDF. It's USAA checking account X 1234 last four, and then the dates or something along those lines. It's gonna save a lot of time. In the grand scheme of your case, it's going to save a lot of time because you're getting over all the documents that your attorney needs to proceed. And then it's also going to save time from a billing perspective because if your attorney or their staff doesn't have to go through and rename the documents, because as attorneys, we're required to produce the documents in a somewhat cognizable manner. Doesn't need to be perfect, but they kind of need to make sense. They need to be held. You got to produce them as they're held in the normal course of business. So, dates and things of that nature. Anything that you can do to help move that process along is going to ultimately resolve in your case moving along quicker, faster, smoother, all of the things that we all want, both as the attorney and client for the case. And then one last thing, and then I'll turn it back over to Matt. The other huge thing about mandatory disclosure that we haven't even gotten into yet is you're not going to mediation unless there's mandatory disclosure that's completed. There's no reason to. I mean, unless there is a court order for some kind of weird off-the-wall reason for you to go to a mediation, you're not going to mediate the case. And we've done podcasts before about how valuable we think mediation is, and every case in Florida has to go to mediation, but you're not going to be able to go to mediation unless you get your mandatory disclosure over. So you're definitely going to want to get the mandatory disclosure much sooner rather than later. And think of it this way: be the party who gets it over quicker and is pushing the case along, not the party who's dragging their feet and having the court orders entered against them, and there might be attorney's fees awarded against you if you're the party dragging your feet, things of that nature. So,
all right, and why do we do it? Why is it a rule? Why is it even required? Well, think about it. You're getting a divorce, all right? You and your spouse, you've acquired assets, you've acquired debts, some things you had before the marriage, which might be non-marital. Everything else acquired during the marriage is going to be presumed to be marital. And we've got to untangle all of that. And we've got to and in order to make sure that we reach a fair resolution and we're able to show the judge that we have competent, substantial evidence that is going to back up a final judgment of divorce awarding equitable distribution, you've got to have all the finances disclosed. They have to be filed with the court, and they have to be supplemented. They have to be current. And the reason for that is because you can't reach a settlement if you don't know what you're negotiating with. Going to a mediation or trying to resolve a divorce case without having full and complete financial disclosure is like playing poker with no cards. It's impossible to do. We have to see how much money is in the bank accounts, how much money is in the retirement accounts, what is the house worth, how is the property deeded. All of these things help not only from an equitable distribution standpoint, but also helps us to fashion a marital settlement agreement that the parties are actually going to be able to comply with. So that's why it's important to see things like, how is the vehicle titled? How is it registered? Is it in both names? Does it need to be refinanced? If so, how are we going to refinance it? What's the balance on it? What's the 45-day payoff amount? All of that stuff is relevant, and you can't get divorced. You can't get divorced without producing these things, because you have to get a settlement agreement or a final judgment before you're divorced, and you can't get a settlement or a final judgment without disclosing your finances, except in the limited scenario of simplified dissolution of marriage. But let me tell you, if you own property, if you're seeking alimony, or even want the possibility of getting alimony, if you want temporary spousal support, if you have children, and you want child support, regardless, whether or not, even if you're willing to waive child support, if you have children, all of those things, simplified dissolution is not going to be an option for you. Simplified dissolution is when you've got, no kids, no property, no real estate, and you're not seeking anything like alimony. Then you could do it simplified. All right, and we do help people with simplified divorces, but most divorces people aren't going to qualify to do it simplified. So it's better just to kind of own it and realize you're going to need to do financial disclosure. And honestly, the faster both parties do it and the more complete it is and the more thorough they do it from the get-go, the faster and the cheaper the divorce is going to be. The divorces that take forever, that drag on, that cost lots of money, are when people are fighting over mandatory disclosure. So, if getting divorced fast, getting divorced cheap are kind of like two of your primary concerns, you want to comply with financial disclosure as soon as you can. Brian touched on it a little bit. There are situations in divorce cases where you need to go in front of the judge right away for some temporary relief issue. Your spouse used to pay the mortgage, you filed for divorce, the spouse isn't paying the mortgage anymore. That's a problem. You don't have the money to pay it, right? So your house is going to go into foreclosure. So what do? You can't force your other spouse to pay it. He stopped paying it. You're going to have to go in front of the judge and you're going to have to ask the judge for an order that's going to force that spouse to keep paying the mortgage. Well, the rule says that you can't get temporary relief if you haven't finished financial disclosure. So it behooves everybody going through a divorce to get it done fast and thorough from the get-go.
Yeah, and a couple of things here. When it comes to mandatory disclosure, it's uncomfortable because you're going to have to send over your bank statements and everything. But there's a few things that people forget that are required in mandatory disclosure. In today's day and age, it's going to be Venmo, Cash App, Zelle, those statements. Those are going to be required. Multiple checking accounts. If you have a lot of people have multiple checking accounts for whatever reasons. Those are going to be required. And it's kind of, in our experience, we kind of know where to look in our clients' information to see if there's anything that's missing. There's a few, you can start to kind of cross-reference things. So Capital One credit card has, $300 payment received from this routing number, and then you Google the routing number and it comes up, it's Truist Bank. But then we look back at the records and we see that the clients didn't give a Truist Bank statement. They only gave a Bank of America statement. Then we know, hey, there's also a Truist checking account out there. And, I say those examples because we see it all the time. And inevitably, if I was going to go do mandatory disclosure personally, Brian Dunmire is going to go do mandatory disclosure personally, there's going to be documents that I miss. There's so many documents that are out there. I've got a number of bank accounts, some that I don't really use anymore, but somebody might find on some sort of credit report or something like that. And so we don't think anything of it when our clients send us mandatory disclosure, and then we take a look at the documents and say, hey, there's another checking account. Can you go get those statements? Because that's part of our jobs as attorneys. And that's fine. But the reason why I kind of say all this is if you are trying to keep something secret because you've got that checking account that maybe has some charges from a certain social media website on it, or maybe there's a few too many charges from an ABC Liquor, Total Wine, or the liquor store or something, don't really have great advice for you other than you got to produce it. And the longer that you kind of play this game, is somebody going to find out, the more guilty you're going to look. And we don't really use the word guilty too much in family law context, but it's a little bit better to just kind of tackle those issues head on, because at the end of the day, although some of those issues might be a little bit embarrassing, or a little uncomfortable, at the end of the day, as it relates to the court system, they don't really care. It doesn't really matter. Now there's always exceptions to that. If there's kids involved and you're an alcoholic and you're spending, $100 a day at the liquor store, that's certainly something that might be relevant. But if you're just kind of going through your stock divorce, you and your spouse have been married for 3 years and you just want to call it quits, and you're a little bit embarrassed because there's a few too many charges from Ale House every day on there, and you think it's going to lead to more, questions and answers, just don't think too much about it. They are what they are. And the more that you try and hide something from that, I mean, you start risking court orders being entered against you, delaying the divorce, added expense, your attorney, picking up the phone, trying to track you down, and all those things. They start to really add up on the bill. It might not seem like it, but they do. When you've got an attorney who's trying to track you down to get some additional information or drafting you correspondence or something along those lines. And we certainly try not to nickel and dime clients by any stretch of the imagination, but when it's, hey, we've got to get this before we send out the document, I mean, we got to do what we got to do. And that's the kind of stuff that runs up the bill. So we've talked about it in the previous podcast before. If there is something that you're embarrassed about or you're just not really sure about, the best time to bring it up to your attorneys at the beginning of the case, because they'll probably be able to put you at rest that chances are it's not that big of a deal. On one hand, I hear something new every single day. I really do. On the other hand, I've heard it all, and that's the same way. I've heard it all. So you don't ever have to worry about any judgment for any actions that you've done in the past. I mean, that almost hopefully would go without saying, but it's covered by attorney-client privilege. I don't really care if you have a pornography addiction. I don't really care if you go to the vape store. I don't really care if you have a marijuana dispensary card. None of that really affects anything. There's always exceptions to it if there's kids involved and there's some nasty allegations going on. But in the vast majority of cases, none of that really matters. So just hit it head on and just knock it out and get it done. And, let your attorneys go over everything, clarify any points, and move on. Finish up mandatory disclosure and move on.
Yeah, and another thing about mandatory disclosure is that you got this continuing duty to supplement it. So it's not just a one and done type of thing. Throughout a divorce case, if your divorce case takes a long time, you're going to have to do mandatory disclosure multiple times. You're going to have, before you go to mediation, if you've done mandatory disclosure and you did it 3 months ago and you got mediation next week, you need to do it again to update it so you can have those most current statements. There's a lot of reasons for that. Imagine if you're on the other side of things and you're going into a mediation and you're about to divvy up the marital assets and liabilities, and your spouse shows up and they've got a financial affidavit and mandatory disclosure that's 3 months old. Well, what if your spouse disclosed everything and then 2 weeks after that got an amazing job and is making double the money, right? And then, imagine if you have an alimony claim or if you got kids involved and you're seeking child support. You're going to want the most current information. Also, the other thing is, in some cases, not all cases, but in some cases, a lawyer might recommend for you to hire a forensic accountant, to get a forensic accountant involved to track money, to identify, if there's any money missing or if any money was transferred out of certain accounts, if, property was deeded to somebody else, try to get it out of their name. If people own businesses, your spouse owns a business, you might want to hire somebody to get that business valued for purposes of equitable distribution, because you might be entitled to it. And if the business was started during the marriage, half that business is yours, whether or not it's in your name or not. Even if the business was started before the marriage, you could be entitled to the appreciation and the value of the business during the marriage. But you can't. What are you going to do? Go hire an accountant, and the forensic accountant just have a conversation with you and just tell you what he thinks? It's not how it works. There's got to be documents to review, and that all takes time. So, if you want to get your divorce done, a lot of people, they're over it. They want to get divorced. They don't want it to last 3 years. They want it to last 3 months. Well, If there's businesses, sometimes properties, sometimes multiple bank accounts, and you need a forensic accountant involved, you need to be able to get the documents, get all the records, and then have enough time to have them reviewed and analyzed by a forensic accountant before going into mediation, or else you don't really know what you're negotiating. So, not only is mandatory disclosure mandatory by rule, but it's also very beneficial to divorce cases, depending on what side you're on, obviously. So really, it's a way, the rule is there to make sure that both parties bring everything to the table, lay out every single thing that you own and every debt that you owe, and get it all out there so that then we can start putting things in different categories, putting things in different baskets to see if we can get a settlement agreement done. And if you can't get a settlement agreement done, if you got to go to a trial in front of the judge, you got to have all this stuff available for the judge to be able to go through at the trial to determine what's going to happen with everything. What you don't want is to get a divorce entered and then find out 3 months later that, your spouse had some business that he was a 50% shareholder in that you never knew about and that you might have been entitled to a significant amount of money. So it's really important from both perspectives to get financial disclosure done, not only to comply with the rule and avoid court sanctions and avoid court orders, but also to reach a fair, equitable distribution of assets and liabilities. Brian, when should parties consider waiving mandatory disclosure or not waiving it?
Yeah, great question. There certainly are cases that you could waive mandatory disclosure and everything's perfectly fine. Generally speaking, if you just wanted a 100% straightforward, non-legal, non-attorney answer, I would suggest never. That's just the simplest answer. Just don't do it. It's a giant pain in the ass, giant pain in the butt rather, but it's necessary because it forces some honesty to occur and there's no funny business. And then also if you waive mandatory disclosure, it can cause some unintended consequences down the line. I don't want to get into just all the different scenarios, but I mean, so many times we see this play out. We get the phone call, hey, my spouse and I, we're getting divorced. We got everything worked out except this one little issue, but I think we'll ultimately come to an agreement on it. So, we just need an attorney to draft up some documents and we'll figure it out or whatever. And then you fast forward 6 months, 6 weeks, 6 months, however long. And, you're just in that classic contested divorce scenario, and it all spiraled because of just natural progression of emotions that people are going through. Because obviously sometimes, we forget, but the divorce is a highly emotional process and not everybody's thinking logically and whatnot. And so if you waive mandatory disclosure today, you never know what's going to happen in the future. And if you waive it, there might be a chance you could unwaive it, you could vacate the waiver or something along those lines. But, then if it becomes a contested divorce, you might be left in this scenario where, well, I know that my husband has a business checking account from his business that he shut down 3 years ago that has $125,000 in it. And we go, okay, well, do you know where that account's located? No. Do you know anything about it? No. Okay, well, if we waive mandatory disclosure, so now, I mean, we can still get the information as attorneys, but we could have just gotten it right out of the gate. So we just really, every case is unique, and we understand that, but we just generally kind of advise against waiving mandatory disclosure. But look, if you and your spouse get along just fine, you have one checking account, maybe you don't have a house, there's no kids involved, your spouse makes $4,500 a month, you make $6,000 a month, it's been status quo, that might be a case where maybe, you go ahead and waive mandatory disclosure. But if there's any sort of complexity involved, multiple properties, if there's kids, I would not waive it. Certainly if there's any businesses, I would not waive it. It's just don't save a penny to spend a pound or whatever, penny wise and pound foolish or something. Something along those lines. I don't know the phrases. I always get those things mixed up. But it's just you really think long and hard before you waive mandatory disclosure. It's not necessarily always the best thing. There are cases that it's perfectly fine in, no issue whatsoever, but some cases you're still going to want it, even if you and your spouse don't give fully complete responses, which you should, but just if you don't, at least there's something on paper. But sometimes our hands get tied real tight as attorneys when we don't have information, and then it turns into a contested divorce case, and maybe we need to get a business valuated, or need to get a forensic accountant on board. And, then they say, okay, we'll send you over the financial documents. And we go, well, we don't have any. So you can't get a forensic. I mean, what are you going to get a forensic accountant for? So I would definitely think twice before waiving it.
Yeah. And think about this. Who wants to waive it? Who wants to waive it? Usually the person that's hiding stuff wants to waive it, or the person that doesn't want their business valued wants to waive it. So, it's just always important to remember, what motive is behind requesting the waiver. Because at the end of the day, as you've heard us talk about it, yeah, it's a pain in the butt, but come on, is it really that hard? It's not. You grab a legal pad, you go through the list of the documents that are required, you brainstorm, takes 5 minutes, you just write down shorthanded what the accounts are that you have. 401k, Edward Jones, checking account, whatever the bank is, savings account, whatever the bank is. You just quickly go, just from your own memory, what are different accounts and things that you own. And then you just log on one after the other, and then you can just bulk download, a year of statements, download, a year of statements, download, most recent statement, download. I mean, yeah, it might take 2 hours of work on like a Sunday afternoon, which is painful, but not that hard in the grand scheme of things. There are things much harder to do in life than mandatory disclosure. But with that, I think we've covered a lot. Obviously, we're not offering legal advice. If you have a lawyer, talk to your lawyer about mandatory disclosure. If you don't have a lawyer and you're considering divorce and you want to know more about mandatory disclosure, by all means, go out and talk to a lawyer and get, case-specific legal advice. We're here just to try to provide some education on the process. But with that said, thank you for tuning in to another episode of Divorce Well in Florida, What to Know Before Your Spouse Does. Again, we're Fairway Law Group, the Florida divorce law firm.